All right. Any further comments on that before we go to the year in review and a breakdown of what's to come in the new year? So let's get out of here. Take the logo down. Steve, have a good new year. Dweeb, have a good new year. Stay out of jail and stop stealing them fucking presents. Let's get out of here. We're going to the law library. One of my favorite places to be. And boy, do I have a doozy for you, Miss Bucket and Judge. We've all seen my videos as of late, right? My arrest video first, and then what caused it second. A prequel to my arrest video. And I pulled it off, I guess. Not many. 11,000 views on this latest video. 25-ish, 20, I forget, 1,000 views on my arrest video. Where people said, he immediately gave up his identification. Listen to me. As soon as you hear the words, you are under arrest, you immediately surrender your ID. That's the law. So, for all you people that are saying that I was whining and crying and I gave up right away, yes, I was whining a little bit. I admit my faults, but nobody likes to be handcuffed. But I did exactly as I was required by law, which proves my innocence. Thank you. And I did exactly 6 seconds after being notified I was being arrested. 6 seconds after I was notified I was being arrested, I said, hey, my wallet is in my car. Let me get it for you. It's right there. Let me get it for you, please, please, please. And we're going to get to the year in review. From the law library, 300 feet deep, safe and secure from any federal intrusion at this point, because it is the federal government, in essence, that's accusing me of shit in McDowell County, but the McDowell County prosecutor took control. I hope you stick in here with me, because it gets fucking brutal in the end. What I'm going to do next year. But for now, we are going to do a year in review. And let me get this up. Number 1, on August 6, 2020, the defendant, Mr. Ballin, was arrested by Trooper Jones. Fact. A, Mr. Ballin was transported to the cardiac unit in Pikesville, Kentucky, and was released from the hospital August 8. Mr. Ballin drove 10 hours from Kentucky, arriving in Philippi, West Virginia on February 8th and 9th. So I'll just say 9th because it was one whole day that I drove. Mr. Ballin immediately contacted Lieutenant Hale of the Philippi Police Department to notify him that a warrant for his arrest was imminent and that if he receives a warrant to contact him immediately to surrender to Lieutenant Cale within 3 minutes due to the closeness of the police department to Mr. Ballin. On August 15th, Lieutenant Cale, look at the time, 8th to the 15th. 1 week later, Lieutenant Cale contacted Mr. Ballin and informed him that a warrant for his arrest was issued on him from McDowell County, West Virginia. Mr. Ballin, within 3 minutes, responded by turning himself in to Lieutenant Cale to see Magistrate Ben Probst. On September 2nd, 2022, Mr. Ballin, 14 days after his initial appearance in the Barber County Magistrate Court, demanded in writing to the McDowell County Magistrate Court a jury trial in the form of a jury election or demand form. Misdemeanor offenses triable before the magistrate. If the charge against the defendant is an offense triable by magistrate, unless the defendant waives the right to a trial on the merits, the magistrate shall proceed in accordance with the rules of the procedure set forth herein. D, demand for a jury trial. When the magistrate informs the defendant of the right to demand a jury trial, the defendant shall also inform that the demand must be made in the court in writing either within 20 days after the initial appearance or 20 days after an attorney is appointed to the circuit court, whichever applies, or the right will be waived and the trial will be before the magistrate without a jury. The magistrate shall further inform the defendant that if a jury trial is demanded, the demand may be withdrawn if the prosecuting attorney objects to the withdrawal. Here is a little bit run over. I admit, it looks pretty rough. But here is the document right here. State of West Virginia versus Matthew James Ballin, blah, blah, blah. As defendant in this misdemeanor case, I hereby demand to have a jury trial. 9/2/2022. Magistrate Mitchell issued a bench warrant for Mr. Ballin's arrest. Number 4, on October 4, 2022, Mr. Ballin received the notice to appear for a status hearing on October 29, 2022. At pretrial hearing, Magistrate Mitchell retracts the bench warrant for Mr. Ballin's arrest due to an address error. B, at this pretrial status hearing, Mr. Ballin disclosed his discovery to and verbally requested reciprocal discovery from the prosecutor. Magistrate Court Rules of Discovery 29 A, C, D, E, and Court Rules number 30. All of this applies, and you'll see why here in a minute. On December 7, 2022, Mr. Ballin contacted the McDowell County Prosecutor's Office to ask for the return of his medical records that are stored on a publicly accessible West Virginia State Police body cam database. Trooper Beggs was in my procedure room filming with his body cam the whole time. A, these 4-hour medical records and procedures of Mr. Ballin were copied in real time by Trooper Beggs' West Virginia State Police body cam.
You have reached the McDowell County Prosecuting Attorney's Office. We cannot take your call right now, but please leave your name, number, and a brief message after the tone, and someone will get back to you as soon as possible. Thank you.
At the tone, please record your message. When you have finished recording, simply hang up or press pound for further options.
This is Matthew Ballin again, pro se. I had called you moments ago about my medical records being stored on a database, a video database in your evidence, as your evidence. My medical records were taken via video for 6 to 8 hours without court order, without consent, without leading to anything dealing with an investigation of the crime that I am alleged to be charged with. The law clearly states that them are my personal medical records, and I would appreciate it if you would give them back to me, along with my other equipment. I also would like for you to preserve any video records that pertain to this. I would also ask if you preserve all records pertaining to this. Thank you very much. Again, my number is... So that was my first attempt early on in McDowell County to retrieve my medical records. What medical records? Let's continue with my year in review. That was audio number 1. On January 17, 2022, Mr. Ballin contacted Magistrate Mitchell's office to inquire about the new trial date. Here's audio number 2. Agent Randy, good to see you.
Virginia. Can't take your call now. At the tone, please record your message. When you have finished recording, simply hang up or press pound for further options.
Hi, my name is Matthew Ballin. I have been waiting for my trial date since November 28th. I've called and I've called. I have not had any answer, nor have I had any response. The only time I ever talked to anybody was Judge Van Dyke, and that was on the 3rd of January, and he said that my trial date would be set in a few days to keep checking. I've been checking my mail. I'm checking my email. I'm checking my phone. I'm getting no phone calls or any information on whether a trial has been set. Thank you. Notice January 17th, January 19th, Mr. Ballin received a notice to appear for a bench trial in front of Magistrate Mitchell on February 21st, 2023. Good. On January 27th, Mr. Ballin contacted the McDowell County Prosecutor's Office to ask about reciprocal discovery. Let's see what that sounds like. Excuse me, I'm sorry. I seem to have gotten a frog in my throat all of a sudden. I'm sorry. My name is Matthew Ballin, and I had just received my my notice to appear for a bench trial on 2/21/23.
Let me get your name and number. The gentleman that sent those subpoenas out, he had to run over to the courthouse real quick, and he should be back here in just a couple minutes. What is your telephone number?
I'm actually functioning as pro se. My phone number is.
Oh, okay.
I have some discovery questions because at the preliminary hearing, the judge had I had already disclosed my discovery to the prosecutors.
Mm-hmm. Okay.
And the judge had asked the prosecutors to get me the discovery 15 days prior to the trial.
Okay.
And I do believe that's work days.
Okay. All right. What was your name again? We'll have him give you a call.
All right. Thank you very much.
Thank you. Bye-bye.
Have a nice day. Bye.
You too. Bye-bye.
Right before trial, I need my discovery. Now we're going to go number 4.
Prosecutor's office.
My name is Matthew Ballin, and I called yesterday, and I also called earlier today at 10, around 10.
Mm-hmm.
I'm inquiring about the judge's order to give me discovery within 15 days of the setting of the trial.
Mm-hmm.
That's coming up on
Mr. Ballin, you said?
Yeah.
Yeah, that all went out in the mail, certified mail today.
Oh, okay, good. That includes body cam and all of that?
Well, they haven't supplied body cam to us yet, and they also they had your GoPro, and they had your cell phone, and the state police sent that off to the lab for some kind of forensics. I'm not sure.
Okay, so that means that
with
you're probably not going to be using the body cam unless you get it to me by the 15th, or by the 31st.
I'm not sure what they have planned. I just know that that's where it's at.
Well,
that's where it's at.
The fact is the 15th is the end date for discovery. Whatever you're going to be using at trial, you're obligated by judge's order to forward that over to me. So I'm surprised that you haven't gotten the body cam or any of the video, which there's a plethora of. I can't believe after all this time, 5 months, that you're not organized enough to have all of this discovery.
Like I said, everything that we've got so far, it's in the mail for you today.
All right. Okay. If there's no body cam video, I'll motion the court and see if I can get body cam. Again, after that 15th day, you can't bring any added evidence in. I mean, that's just a fact. Unless there's extenuating circumstances. Of course, you could always bring evidence in the middle of the trial, but there are certain conditions.
Right. Well, I'm not versed in law. I just answered the phone up here. All I know to tell you is what we did have. It's in the mail for you. Okay.
All right. That's fine. All right. Thank you very much for your time, and have a nice day.
You too.
All right. That was Josh at the prosecutor's office. Josh is a nice guy. Him and I had some conversations. Nice guy. Josh is a nice guy. That was right here, number 4. On January 31st, 2023, Mr. Ballin traveled 4 hours to McDowell County Prosecutor's Office to pick up reciprocal discovery. Magistrate Court Rules of Discovery 29 ACDE Court Rules 30. I still have not received discovery, and it's days away from trial. Like 5 days away. Still haven't received discovery. I wonder where it's at. Let's see where it's at, shall we? It was a long journey.
My name is Matthew Mallon.
Oh, okay.
And I've been talking to you. Am I the one you've been talking to?
Yeah, okay.
Josh!
Apparently you've had some problems downloading or uploading that video for me.
It was too big to email.
I thought so.
Yeah.
That's why I come down this morning to get it on a zip, on a thumb drive if I could.
Yeah, we can just burn it on disk for you if you want that.
Yeah, we could do it either way. And I also have more discovery for you.
Okay.
Whew. Boy, I'm not used to being out. Yeah. If you could sign that for receipt.
All right, I want my discovery. So if I have to go get discovery on my own, I'm going to do it before a long holiday weekend on February 17th. A month later, less than a month later, Mr. Ballin received an email from Prosecutor Brittany Puckett. In the email was a copy of her motion to the court for a continuance. The state of West Virginia, in the above matter, hereby moves the court to continue this case from the currently scheduled date of February 21st, 2023 at 10:30 a.m. This motion is based upon the following grounds. The state was contacted by Trooper Ricky Bobby Sue Jones and was advised that the West Virginia State Crime Lab will not have the drone footage copied until next week, and he will pick it up then. Therefore, we respectfully request a continuance in the above matter. Drone footage. Eyes in the sky. Do all my drones in here? I have drones. Everybody duck. That was a drone. Do I have any more drones? Yes. Oh, watch out. Drones. Ouch. Watch out. What about these kind of drones? Watch out. There's a drone! Drone footage! She got drone footage, I'm sure. Look at the wings on that drone. Wow. It was never produced. It come out of fairy dust, I'm sure. Watch. Let's continue. On February 21st, 2023, Mr. Ballin filed multiple motions with the McDowell County Court. A, quash the prosecutor's continuance, a motion for a speedy trial, and a motion to dismiss all charges. Quash prosecutor's motion, 21 February 2023, received. Okay, let's go down to the important part. The prosecutor's unnecessary delay tactics and frivolous motions are in violation of the 14th Amendment of the United States Constitution. Malicious prosecution. Rule of Criminal Procedure 16C, discovery and inspection. Continuing duty to disclose. If, prior to or during trial, a party discovers additional evidence and materials previously requested or ordered, which is subject to discovery or inspection under this rule, such party shall promptly notify the other party or that other party's attorney or the court of the existence of the additional evidence or material. That sounds like drone footage, right? Drone footage? Did somebody say drone footage? Yes. Shh. Shh. There's drone footage out there. Shh. Okay. Thank you. Thank you. The West Virginia State Police Organization has recently been under investigation by the Department of Homeland Security for possible corrupt acts of a substantial portion of the leadership team. A reasonable person can deduce a correlation between the chaos at the top levels of the West Virginia State Police and the delay in acquiring drone footage, state-owned evidence in brackets, emphasis added. To the prosecutor in this case, there has been no oversight of training by the leadership of the West Virginia State Police to its subordinate troopers. Thereby, I claim this case is being prosecuted by two rogue state troopers, one being a leader, making up their own laws alongside of the road in order to entrap the press, in quotes, in an unlawful cycle of criminal prosecution in lieu of a lawful post-conviction punishment. Isn't that beautiful? The prosecution has had access to the defendant's cell phone and GoPro 360 for 7 months. These videos have not been rendered into discovery as evidence for trial. I claim the same erosion of trust, oversight, lack of training, and chaos from the highest levels of the West Virginia State Police is another correlation between the delay in acquiring privately owned property, in brackets, emphasis added, from the West Virginia State Police as well. The prosecution has exculpatory evidence given in discovery 2021 Fourth Circuit Court, Wingate versus Fulford, maps and deeds. Due to the prosecution's delay tactics and chaos at the highest levels of the West Virginia State Police, the defendant has been stripped of many of his rights. I motion this court to order the prosecution's continuance be quashed. Beautiful, right? Was that not great? Second motion I filed, enable a speedy trial without delay. Speedy trial, there's the case law. I was in state confinement for 7 months. West Virginia State Police, drone footage, state-owned evidence, all of that. Same thing, prosecution has had access to the defendant's cell phone for 7 months. Exculpatory evidence the prosecution's had. I motion this court to order the prosecution of this case post haste, or all charges be dropped due to undue delay by the prosecutor, prosecuting staff, and state police. This motion is to ensure my rights to a speedy trial. Isn't it great? Okay, let's move on to the next one. What's the next one? Dismiss all charges. Fourth Amendment violation. The warrantless arrest and search and seizure of the defendant and property was on August 6th, 2022. The prosecution cannot act as magistrate to impose further confinement through bail conditions on the defendant simply by asking for a continuance to gather state-owned evidence. The prosecution's unnecessarily delayed tactics, frivolous motions, are in violation of the 14th Amendment of the United States Constitution, malicious prosecution. Rules of Criminal Procedure 16C, discovery and inspection, continued duty to disclose. I read that earlier. Here we go again with the state police. The prosecution has had access to my cell phone, blah, blah, blah. The prosecution has had exculpatory evidence. Due to the prosecution's delay tactics and chaos at the highest levels of the West Virginia State Police, the defendant has been stripped of many of his rights. I motion this court to order that all charges be dismissed. What's next? On February 28th, 2023, Mr. Ballin received from Magistrate's office a new trial date for March 23, 2023. On March 9th, Mr. Ballin contacted the McDowell County Prosecutor's Office to inquire about drone footage. Magistrate Court Rules of Discovery 29, A, C, D, and E. What did they have to say? Let's hear what they had to say. Yes, ma'am. This is Matthew Ballin again. I'm sorry for bothering you, and I will be brief. You have my email. I have given you my email. Would it be possible?
I tried to email it and it kept returning it. Give me that email again.
Okay. That was written for the continuance.
All right. I will send that right now. I am in the process of typing it in, and I've already got it scanned into my computer, so I will, while you're on the phone,
Yes.
see if you received it.
Remember, this is about my continuance, my motion for continuance.
So I also put a copy in the mail to you.
Okay.
So,
I'm sorry. Thank you
all
very
the
much for
motions I
that.
just
I
went through.
appreciate that. And I didn't mean to be obtruse earlier.
no problem. No problem.
It's been 6 months, hon. So, bear with me.
No problem. And like I said,
I got it.
Copy of mail.
Brittany,
Okay, good.
Brittany Puckett, continuance.
Yes.
Okay. And you had something to say? I'm sorry to cut you off.
Oh, no, I was just going to tell you, I did go ahead and put a copy of that in the mail, and that way, because my issue was we're closed on Monday where it's President's Day, and I was afraid that you was going to drive down on Tuesday, and there wasn't any need in it, so that's why I was trying to get a hold of it.
Okay, who's your favorite president? Who's your favorite president? No, I'm not going to put you on a spot like that. Abraham Lincoln. I bet it was Abe. Good old Abe, right?
George Washington.
George Washington the first. Good for you. You must like men with powdered wigs.
Yeah.
Yeah, that's funny.
Yeah, considering my husband has no hair, yeah.
That's funny. Also, if I could get a copy of the drone video, and I can come down and pick that up at your convenience.
Yeah, as soon as Trooper Jones brings that up here, he said when he goes and gets it, he'll just bring it straight here. And whenever he does, we'll go ahead and make you a copy of it and let you know.
All right, let me know so I can come down and pick it up, and we'll be good to go.
All right, thank you so
All
much.
right, have a nice holiday.
You too. Bye-bye.
Yeah,
President's Day, powdered wigs. Yes. Okay.
Is everybody following? Is everybody following? I hope everybody's following along because it's going to get good here in a minute. As if it isn't already good. March 15th, 2023, Mr. Ballin received a package from the McDowell County Prosecutor's Office with the West Virginia State Lab report and data from his GoPro and iPhone. Mr. Ballin inquired about no drone footage, GoPro or iPhone footage included. Magistrate Court Rules of Discovery 29A, C, D, and E. Let's find out why there isn't any videos. Yes, this is Matthew Ballin. How are you doing today?
Not bad. How are you doing?
I'm doing good. Do you remember me? I come down a few... Yeah. When we were in the continuance hearing, the continuance hearing was premised on drone video. The trial date has been set, and I have not received any drone footage, and it's 9 days to trial.
Yeah, I'm not sure that we...
Well, your letter had stated that Trooper Jones had contacted the state troopers and it would be available last week. Well, yeah, the prosecutor.
Oh, the prosecutor knew that?
Yeah, you sent me a letter. That's what the continuance was over. You filed a continuance because you had drone footage that you were going to get last week from Trooper Jones.
If you don't mind holding on for just a second, let me pull your file.
Yeah. I appreciate your time.
Hey, I flipped through your file. I don't see anything, any new footage added to your file here.
Well, that was the whole premise behind the continuance is this drone footage. And like I said, in the letter, it stipulated that Trooper Jones would have that last week. I was led to the impression it was going to be around Wednesday. So I let you have a week or so to review that before you released it to me. I mean, I was just wondering if it's there because I need to prepare for the case. I need to prepare for my case, and 8 days isn't following the rules and procedures of magistrate court.
Now,
either that or you're not going to use any drone footage.
that's what I was wondering. I'll have to talk to Mr. McGinnis. He's the one that was handling that one.
Yeah, and you know, I don't know if you're required to tell me, but you know, a common courtesy would say that if you sent me a letter saying you had drone footage, that you would also give me the same common courtesy to say that it's not included. It's not going to be included in evidence.
Yeah, I'll have to check with Mr. McGinnis to see exactly what's going on with that.
And I appreciate.
If we got anything new, like I'll be the one to like actually put it in your file and send it to you.
And I really appreciate your time. A lot of times the prosecutor's office won't even talk to a pro se litigant. But I really appreciate your time, and you've been really, really good. I commend you.
Well, I appreciate that. But when I got your number and information here, after I talk to John, I'll call you and let you know what's going on with that.
All right. It's 9 days, so you know it's kind of either it is or it isn't. Otherwise, if it is, I'm going to have to head back down there.
Right. But I'll find out something for for you today, and I'll call you back here in a little bit. And,
All right, I appreciate it, brother.
Is there any particular time you prefer?
Nope, you can call me any day and night, but you don't call me late for dinner.
Right. All right. I'll see what I can find out for you, and I'll let you know something, okay?
All right, thanks, bye.
Uh-huh.
Humor? Who said anything about this fat man being funny? I mean, do you think I'm funny, Nat? Red-Eyed Rick, do you think I'm funny? Number 14 down here. On March 15th, remember, that was the 9th, another almost week, Mr. Ballin received a package from the McDowell County Prosecutor's Office with the West Virginia State Lab and data from his GoPro and iPhone. Mr. Ballin inquired, note the drone footage, GoPro, or iPhone video footage included. Let's go to 8.
At the tone, please record your message.
Jason, this is Matt Ballin again. I received your package today. I was just inquiring. Apparently, there's no video off of my GoPro, and it's just 2 images, I do believe. Just give me a call back and let me know if I'm missing something, because I do not believe there are any video files that are associated with what you gave me. So just to confirm that there are no videos off of my GoPro, and of course the drone footage is not existent. Give me a call back, please. Thank you.
Heading on down the path. Where's the shit at? Where's your evidence? On March 16th, one day later, Mr. Ballin contacted McDowell County Magistrate Court to tell them he would be in for the following day to file motions with the court. I wonder what the motion could be. Let's listen.
Okay, I'm calling from Danny Mitchell's office.
Yes, ma'am.
Magistrate Court. I want to make sure you received your notice because I noticed there's 2 different.
Yes, I have actually 3 different addresses in 3 different states.
Oh, okay.
So,
you know your court's the 23rd.
Yeah, I did get the notice of a bench trial on Thursday. I'm most likely going to be filing a motion tomorrow to continue because the prosecution just got done dropping about 14,000 files on me from the state police crimes lab.
I don't know anything.
Yeah. So I'm going to probably head down there tomorrow, and no doubt tomorrow, to file a motion to continue so that I can review all the information that they had given me.
Okay. All right, then.
All right.
All right,
Thank you for your courtesy in calling me as a reminder. I really appreciate it.
Okay, you're welcome.
Thank you. Bye-bye.
I'm not too mean, am I? Oh, no. Where is this mean beast animal that he shows us out on the outside? Where's the out-of-control lunatic? He can't possibly be one and the same. Go figure. Okay, let's move on. Here's the motion. Motion for a continuance. The state has consistently violated Rule 29, discovery in a misdemeanor action. Timing of discovery from the state. If discovery is requested by the defendant, the relevant discovery material shall be provided at least 21 days. Not 8, not 5, not 8, not 5. Okay, that's all. That's all for that motion. That was easy, right? A motion for return of the defendant's property. Of course, I'm going to file another motion. I want my property. I want to see my own evidence that I shot myself. Let's see what I have to say. Return of the property based upon them having it for so long. And the state troopers were done with it, the lab. They don't need my hard drive. They don't need the hardware. So, that's what my motion for the return of property was, and you'll hear it right here. These will drop out here. Here. On March 21st, Mr. Ballin contacted Magistrate Mitchell's office to follow up on the motion he filed with the court. The motion for the continuance and motion for discovery. Let's find out what is said. My name is Matthew Ballin. I do believe you had called me once before. I don't know if you remember my name.
Yes.
Yes, I had on Friday filed a couple motions with the court. One of
Yes, I
them.
got them.
Okay, I was just calling
Yeah,
to.
I got two of them.
Yes, ma'am.
A motion for continuance and motion for return of defendant's property.
Correct.
Yes, I got both of them, but Magistrate Mitchell won't be back until tomorrow, so if he calls in, I haven't talked to him over the phone yet, I'm gonna tell him about these, but if he doesn't, he'll look at them in the morning.
All right. Either way, I hope I can be prepared to, that I'm prepared enough to put my case, my defense on. Either way, I just have a lot of information to go over, which the motion for continuance explains.
Oh, okay.
It was new information that was dropped on me by the prosecutor. It was a thumb drive with 14,000 files on it from my phone. So I just needed more time to go over the information that was just dropped on me.
Oh, okay. Okay, I'll let him look in. It looks like you got a phone number on here, so.
Yes, ma'am, I do. Please keep me informed. Either way, I'm going to drive all the way down there for my trial on Thursday.
Okay, all right then.
All right, thanks.
You.
I'm just so mean to these people. Good Tugga, stop being so rude. All right, let's go to number 11.
Magistrate Dennis's office.
Yes, ma'am, you just tried to call me back. For some reason, my voice, my Google Voice, I don't have a phone. I have a Google Voice number, and sometimes it gets glitchy like that. I'm so sorry.
Yeah, it sounds like there's somebody on there, but there's nobody on there.
Yeah, is it fine? Is it fine now?
Yeah, I can hear you good, but I did get a hold of Magistrate Mitchell, and he's going to grant your continuance.
Oh, great. All right. Thank you.
So I'm going to reset it, and then the date it's reset, you can have the motion hearing on that date too.
For return of property?
Yeah.
Okay, so
yeah.
I'm going to have to be down there on that date, correct?
No, he's continuing it.
Yeah.
So I'm just going to reset everything.
Oh, okay. And then I could, I need my property back pretty quickly.
Okay, did you send a copy of this to the prosecutor's office?
I did. I hand delivered it.
Okay,
My property's been, all the property that was seized, the crime lab has completed it, and they had forwarded all of the information, including the hardware, to the investigating officer. And the investigating officer had delivered, at least as I understand at this time, the report, because I got the report, and that's what I need to go over.
okay.
I'm just inquiring where the hardware is. Does the prosecutor have it? And can I have that property?
I can ask them about this and see, but as far as the hearing on the 23rd, you don't have to come that day.
Okay. And in the motion, if you need more clarity, you could read in the motion the premise behind if they have a duplicate of my phone, why do they need my hardware?
Yeah. Okay.
And
Right,
Miss McCabe, as I see it, and I've read some of the documents. I've read Miss McCabe's analysis of the phone, and again, she said that she had given that hardware to the trooper, the investigating officer. So I'm just asking for the return of my physical property, since there's no need.
That's something the prosecutor's gonna have to do.
Well, I asked the prosecutor.
See what they're doing.
Well, I asked the prosecutor whenever I hand delivered the motion, and they've been great down there. The prosecutor, your whole team has been great. The staff has been fantastic. I love your staff. But the prosecutor, I forget the guy's name. He isn't handling the case. He has just sat in on the preliminary hearings. And the prosecutor, she was gone. She was in Wyoming County.
Oh, okay.
So he couldn't make the determine whether to get me back my property at that time or not.
Okay.
And I said, that's fine. I just wanted to work this out. And because if you gave me my property back, there's no need for this motion.
Yeah. Okay, I'll try to get a hold of her, and if I can find out anything, I'll give you a call.
Oh, that would be fantastic. I appreciate that, and thank you very much, and have a nice rest of the day. If you don't get back to me today.
Okay. Same to you, okay?
All right, thank you.
right.
Bye-bye.
All right, bye-bye.
All right, moving along. Now it's March 21st. 1 week later, March 27th, Mr. Bowling contacted the McDowell County Prosecutor's Office inquiring about the West Virginia State Crime Lab report and the return of his property. Not again! Why are you hounding these people, Tugga? Would you just leave the prosecutor alone? Don't you understand? They have murder cases that they have to deal with. Okay.
Prosecutor's office.
Is this Josh?
This is Jason.
Oh, I'm sorry, Jason. I'm sorry.
Mr.
My son is named Josh. My son is named Josh, and that's why I did a little slip there.
Yeah, that's okay.
How are you doing today, Jason?
I'm not too bad. How are you?
I'm doing good. I was inquiring. Now, I had put a motion in for a return of property, and I had talked to the assistant prosecutor the day that I dropped that motion off. And I had asked him, instead of going through the judge, if we could just have my property returned to me, if we could just drop that motion. And I'm just calling to inquire about that. He said that the prosecutor, Brittany, was out of the office last Wednesday until Wednesday, and I figured I'd give you a little bit of time to find out.
Was that John you talked to, John McGinn?
Yeah, he's the one, the prosecutor that's been sitting in all the preliminary hearings.
He's down in Judge Marinsky's court right now. He hasn't said anything to me about it, which I know you put in those motions, but he hasn't mentioned anything to me about. Did that motion get dropped, or did y'all go ahead and go through with it? For the return of property.
No, it's still in the process of
Okay.
being heard. I mean, y'all have 14 days to respond to that, but I'm just trying to get it done prior to it going into court because it's a 4-hour trip down there. I haven't even gotten a hearing date yet for my continuance. So
Let me see here. I was looking up to see if they rescheduled your hearing too. They haven't rescheduled it yet.
damn straight, right?
And they've already got all the stuff off it that they wanted to.
Yeah, it was returned from the crime lab. They have an exact clone of the image itself, or a direct clone image of my hard drive. Both,
Yeah.
I'm sure.
John's down in Marinsky's court right now. He should be. His thing was at 10:30, so he should probably be about done here in a few. Just as soon as he gets up here, how about I give him a call, because he'll be able to tell you a lot more. As soon as he comes up, I'll run it by him and have him give you a call. So, because as long as they got all that stuff, I don't see why they need to keep it.
I concur. But hey, that's you and me talking. That's all right.
Yeah, right.
They
got their own.
they got their own way of doing things.
Yeah.
Yeah.
But I'll definitely get with John when he comes up and have him give you a ring, and he could probably tell you a whole lot more than I can.
All right. Thanks a lot, brother.
All right, no problem.
See ya. So 1 day later, I'm hitting up the prosecutor. I'm sorry, the magistrate. Hello, my name is Matthew Ballin. I had a continuance that was granted about 2 weeks ago, and I'm calling to find out if there has been a new trial date set. I also filed a motion to have my property returned. It has been, the analysis of it has been completed since February 1st, and there's no longer needed the hardware. I'm asking for that back also, trying to find out if the judge has granted that motion. Please give me a call back. I'm hitting everybody up hard in a nice way, cordial with humor. Who would have ever thought? Line 1 knows that I'm not funny. Line 1 has never giggled at one of my jokes. Not one of them. She's tough. She's hard to humor. I bet she laughs at that one. Let's go to 14.
Or press pound for further
Today about a rescheduling of a trial date. And a motion that was filed for return of property. Can you please give me a call back with a rescheduled date? If not, that's rescheduled yet, that's fine. But I would like to have my property returned. I'm hitting them up hard. My phone number. All right. So that's all the audio I have. From this point forward, we're going with this document. On August 28th of 2023, 1 year and 1 month later, Magistrate Mitchell's office called and let Mr. Ballin know the trial date was set for August 30th. Wow, 2 days notice. Thanks, Judge. They sent the notice to appear via U.S. postal mail, and it was kicked back to them as undeliverable. Well, let me tell you something. I moved in July, so I was in my house, July 1st, I was in my house for almost 2 months. I never received it. Don't know what happened. Have no clue what happened. So, on August 30th, 2023, at around 3 p.m., before trial, Mr. Ballin was sitting in the waiting room at Magistrate Mitchell's office in Welsh, West Virginia, when Trooper Jones stood outside the magistrate's door and offered Mr. Ballin a plea deal. Mr. Ballin's choice was to either plead guilty to a trespass and the obstruction charge would be dropped, or plead guilty to the obstruction and the trespassing charge would be dropped. Mr. Ballin denied Trooper Jones's plea deal because Trooper Jones is not in the judicial branch. He is in the executive branch. Therefore, any agreement by the defendant was made in fear of retaliation from Trooper Jones. Trooper Jones can arrest a motherfucker when he leaves the courtroom. Pull you over. You can have somebody waiting outside. Am I going to make a plea deal with a man that can arrest me if I do say something wrong or disagree with his opinion on what I should take? Does that make sense? Doesn't make sense. Why are you, Trooper Jones, coming out here and giving me a plea deal? 20A. Why is Trooper Jones acting as the judicial branch prosecutor to offer a plea deal to the defendant? Question mark. B. Is Prosecutor Puckett sending Trooper Jones to offer Mr. Ballin a threat or a plea deal? West Virginia Criminal Penalty 11, E1, the attorney for the state, emphasis added, and the attorney for the defendant or the defendant, when acting pro se, may engage in discussions with the view towards reaching an agreement that, upon the entering of a plea of guilty or nolo contendere to charged offense or to lesser or related offense, the attorney for the state, emphasis added, the attorney for the state, emphasis added, will do of the following. Hello? McFly? Why is Trooper Jones offering me a plea deal? Shouldn't it, under West Virginia criminal procedure? Says the attorney for the state. It doesn't say anything in there about no fucking trooper giving me an offer of a plea deal. Trooper Jones. Miss Bucket. Number 22. At trial, Mr. Ballin objected to video evidence not given to him in discovery. This is at trial. The magistrate asked Prosecutor Puckett, how long are the videos? Trooper Jones, sitting at the prosecutor's table, responded to the judge. 2 videos lasting 3 minutes and 3.5 minutes. Unquote. Magistrate Mitchell affirmed the showing of the videos to Mr. Ballin. All of the prosecutor's video evidence appeared to be on Trooper Jones's West Virginia State Police laptop. 24. Trooper Jones asked the prosecutor something. This is at trial. This is in the middle of trial. At trial, Mr. Ballin objected. I object to the video. I never received it.
I've been asking for this video for months. Please give me my phone back so I can look for myself. Please give me my GoPro back so I can look for myself. The evidence that I filmed for myself, my property, I should be entering it as my evidence, not the other way around. So now here we are at trial, and Miss Puckett wants to play the videos that I've been asking for all the fuck along. Of course, I'm going to object, which I did. How long are the videos, Miss Puckett? And Trooper Jones, sitting at the prosecutor table, responds, why are you responding, Trooper Jones? Is it your job to respond to the judge's inquiry? Trooper Jones, 2 videos lasting 3 blah, blah, blah. Okay, Magistrate Mitchell affirmed, hey, show Mr. Ballin them fucking videos. All of the prosecutor's evidence was on Trooper Jones' laptop. Trooper Jones asked the prosecutor something to the effect of, quote, do you want to go into the room and play the videos? Trooper Jones, with the West Virginia State laptop, in tow, entered the conference room first, then Mr. Ballin second, and then Miss Puckett third. A, 24A. Why is Trooper Jones in the conference room acting as if he is in the judicial branch as assistant prosecutor? Why is he there? 25, this is at trial. At trial, as Mr. Ballin is in the doorway, he looks back over Miss Puckett's right shoulder and observes Lieutenant Looney on the stand, pointing at Mr. Ballin. Lieutenant Looney then looked at the magistrate and whispered something to him. Don't know what it was, but I saw it. A, as Mr. Ballin was standing by the door next to Mrs. Puckett in the conference room, Mr. Ballin observed Miss Puckett had left the door ajar. So much so that Mr. Ballin could see and hear Lieutenant Looney on the witness stand talking, giggling, and conversing with the magistrate while pointing his finger in the direction of the conference room. 26. While in the conference room, Mr. Ballin and Miss Puckett were standing. Trooper Jones sat down at the table and played 2 videos that were not the correct videos as Mr. Ballin argued in his objection moments before. Mr. Ballin said to Trooper Jones, quote, just like there was no, what? Drone footage. There was no drone footage. Do you have drone footage, madam? Are you spying on me right now, Barry? Yes, I was in that conference room, and I said, hey, Trooper Jones, just like there wasn't no drone footage, right? Right here. That you delayed this trial for, unquote. Trooper Jones, in an angry and intimidating fashion, told Mr. Ballin what? Quote, this is a courtroom, and if you continue, I will arrest you for willfully disrupting a government process. Mr. Ballin immediately sat down to watch the video being played at full volume while Miss Puckett kept the door cracked, so all out in the courtroom could hear the full volume of the video being played. Chapter 61, Crimes and Their Punishment. Article 5, Crimes Against Public Justice. Trooper Jones, listen up. You're going to want to hear this one. Trooper Ricky Bobby Sue Jones. Here we go. 61-527, intimidation of and retaliation against public officers and employees, jurors, and witnesses. Fraudulent official proceedings and legal process against public officials and employees. Penalties. Intimidation and harassment. B, it is unlawful for a person to use intimidation, physical force, harassment, or a fraudulent legal process
or official proceeding, or to threaten to do so where such threat is directed at inciting or producing imminent lawless action of a violent nature that could cause bodily harm and is likely to incite or produce such action or to attempt to do so with the intent to, number 2, impede or obstruct a juror or witness from performing his or her official duties in an official proceeding. Number 3, influence, delay, or prevent the testimony of any person in an official proceeding, or C, retaliation. It is unlawful for a person to cause injury or loss to a person or property, or to threaten to do so where such threat is directed at inciting or retaliate against any other person for attending, testifying, or participating in an official proceeding, or for the production of any record, documents, or other objects produced by a person in the official proceeding. Trooper Jones, why are you trying to arrest me to watch the video that the judge said I could watch? Trooper Jones, why are you threatening me in a conference room where you should have never fucking been? That's right, John D. Nicola, you are getting it. Hold on, John D. Nicola. What are you talking about, ex parte? Shh, shh, shh. You're too smart, John D. Nicola. You're smarter than all the other average wannabe lawyers, esquires. Number 26, Mr. Ballin observed Miss Puckett purposely pulling on the doorknob and opening and closing the door slightly. As the video played, the defendant's voice on the video being played was at full volume for all to hear inside the courtroom, including the witness, Lieutenant Looney, the jury, and the magistrate. See, while in the conference room, Mr. Ballin witnessed quite a bit of talking and loud commotion going on out in the courtroom due to the fact that Miss Puckett had her hand on the doorknob of the door the entire time inside the private conference room, emphasis added. Opening and closing the door slightly depending on the volume inside. The sequestered, in quotation, conference room. When the sound in the conference room was loud, Ms. Puckett cracked the door open wider. This is how Mr. Ballin was able to witness the sights and sounds of Lieutenant Looney testifying under oath while in the absence of either legal representation. Boom. Can I get a boom? Can I get some drone attack on that one? Let me see. Yes. Drone attack. Oh. You didn't think that I could see you, did you, Looney? Carrying on like a fool. Did you? Thank you, Miss Puckett, for keeping the door cracked. Number 27. The video was almost over when Mr. Ballin noticed on Trooper Jones's laptop at least 30 more video files that were not originally received in the initial reciprocal discovery from the prosecution. Mr. Ballin then proceeded to go into the courtroom to object one more time about the volume of 30 videos on the laptop he never received in reciprocal discovery. 28. Magistrate Mitchell continued the trial until further notice. That's where we're at now. File for a change of venue? Oh, you're starting to think ahead again. John D. Nicola, does anybody else have any ideas what I should do? Because, after all, it is a year in review and a happy new year of trials and tribulations of what's to come. So put your thinking caps on, people, and think of what you would do instead of Jesus. Jesus was falsely accused, but I'm not like saying that I was Jesus or anything, but damn, on Christmas and everything, it kind of touches me. Let's continue. 29. Trooper Jones is an individual acting in many capacities that the defense fails to understand. A. Is Trooper Jones acting as a legislator
making up his own obstruction laws along the roadside? Is Trooper Jones acting as a state trooper, ignoring legislative obstruction laws alongside the roadside? C, is Trooper Jones a witness and or a lead investigator testifying at trial? D, is Trooper Jones acting as a prosecutor to offer pleas and to convict on legislative obstruction laws? And if so, can Trooper Jones then offer plea deals to any arrested pro se defendant moments after placing them in handcuffs? Great fucking question, right? Why not just cut to the chase, Judge Dredd? Ricky Bobby Sue Jones? Put the handcuffs on him and say, hey, you want to make a plea deal? Does Trooper Jones have a bar card? Isn't this fun? It's going to be a good new year, as you can tell. I'm getting there. Can you see where I'm going, Miss Bucket? And since it's Christmas, I'm not going to go all the mean and stuff. I'm trying to be nice for the new year. Not swear so much. You know what I mean? For fuck's sake. E, there's another one. Is Trooper Jones acting as magistrate to threaten to hold Mr. Ballin in contempt and then arrest him for willfully disruption of a government process for Mr. Ballin simply asking questions of an opposing counsel while in brackets, private room, emphasis added, in brackets, sequestered from witnesses and judge? Good fucking question. Number 30. The defense is at a loss to understand what role Miss Puckett has Trooper Jones in. Is Miss Puckett prosecutor or is Trooper Jones? Another good question. 30A. The defense asked this court to define who is prosecuting this case. Does that make sense? Malicious prosecution? Number 31. Throughout September till the present, Mr. Ballin has reviewed the discoverable material given to him by Trooper Jones at trial, and several troubling facts have been found so far. Oh no, not troubling facts with their discovery to me at trial. A, this copy of the West Virginia State Crime Lab report, the video, and data in the batch of discoverable material given to the defendant during the trial does not match the last saved modification timestamp of the reciprocal discovery given to the defendant in the previous discovery in March of 2023. The March batch received via U.S. Postal Service from Ms. Puckett to Mr. Ballin has a timestamp of 1:30:23 at 3:19 p.m. juxtaposed to the discovery given to the defendant from Trooper Jones's laptop at trial as a timestamp 1 hour later at 4:19 p.m. B, the March 2023 West Virginia State Crimes Lab report by Ms. McCabe, the folder, quote, resources was missing. Juxtaposed to the discovery by Trooper Jones to Mr. Ballin at trial, the file, quote, resources is present. The file resources is vitally important due to the fact that all HTML links to the West Virginia Crime Lab report are stored in this folder. These HTML link files are web browser links to the original copy of Ms. McCabe's report, including links to all .bin files recovered by Ms. McCabe. C, in March 2023's version of the West Virginia Crime Lab report, Ms. McCabe, the one HTML link in that folder is broken, juxtaposed to the version of discovery given to Mr. Ballin by Trooper Jones at trial. This version of the report's HTML link works. This link directs you to the entire report, not just a synopsis of the report by Ms. McCabe given to Mr. Ballin in the initial discovery in March. D, if Mr. Ballin did not object at trial
to discoverable materials that he never received before trial, would never have known that these files existed and were tangibly accessible for review and inspection by him at his leisure. Witness tampering? Oh no, John D. Nicola, you're just hurting me here. You are just hurting me. Stop it. Number 32. At this point, Mr. Ballin's due process rights have been violated. He cannot field a proper defense against manipulated evidence. The mere fact that two identical files have been presented to the defense at discovery phase and at trial months apart, have two different timestamps, 1 hour apart, indicating two copies of said report. Since the defense had the earlier copy of these files, folders, and data at the start of the trial, the prosecutor, Ms. Puckett, presented at trial an illegitimate timestamped 419 version of all files on the West Virginia Crime Lab report completed by Ms. McCabe on February 1st, 2023. Therefore, in this case, there are grounds for all charges to be dropped, the case to be dismissed, and this blemish on Mr. Ballin's clean record be immediately expunged by this court. Boom. Can I get a drone? Please give me a drone. Where's my drones at? That's definitely a big drone right there. That's a big one. Pretty sharp. Pretty sharp. What do you think? John D. Nicola, stop. Or would you just stop with this? Knowing the rules and procedures governing magistrate courts in West Virginia. Renew my motion for a speedy trial. That's a good one. I like that one too. That would push the issue. But think about going for the throat, John D. Nicola. If you want to go for the fucking throat, which I'm doing in this synopsis of a year in review, what would you think I'm doing with this? Why am I writing it the way I'm writing it? There are other more severe things you could do. Number 33. The Sixth Amendment guarantees the right of a criminal defendant right to a public trial without unnecessary delay, and the nature of the charges and evidence against him. 14th Amendment guarantees the right to due process. The motion to move to a federal court. John D. Nicola, that's using your noggin. But no, that's not it. Keep on guessing. Number 34. Trooper Jones placed the cart before the horse as he had no probable cause of an initial crime to arrest the defendant for the secondary charge of obstruction, which makes the trespassing charge fruit from a poisonous tree. Ew, yucky. Motion to suppress. That's another good one, but no. Number 35. The state, Ms. Puckett, and Trooper Jones have shown that they cannot act in good faith in many areas of this case, including but not limited to a frivolous motion for a continuance due to newly acquired drone footage. Newly acquired. That never existed. The prosecutors delaying discovery to the defendant up to 5 days before trial violated Rule 29D, discovery and misdemeanor actions. Timing of discovery from the state. If the discovery is requested by the defendant, the relevant discovery material shall be provided at least 21 days in advance of the date of trial, provided that the request has been made at least 14 days in advance of the date the respondent is due. 37, the defendant has shown with timestamp motions to this court and by the actions of the prosecutor and Trooper Jones that during this case, they have defrauded this court and arbitrarily stripped many civil rights from the defendant. 38, the defendant charges that through omission of evidence, the prosecutor and Trooper Jones and or both have hidden from this court and the defendant exculpatory evidence, HTML links, folders, files acquired by Trooper Jones, from the West Virginia State Forensic Lab that prove that there was no crime committed by the defendant the day of his arrest on August 6, 2022. Oh, stop. Tugga, would you just stop? It's just rolling off of your tongue like a rap. Set it to music, Tugga. Set it to music. 39. The defendant filed a timestamp motion with this court on March 17, 2023 for the return of his property. This property was vital to his defense. The defense had the right to view his own evidence on his own property that was produced by him. The defendant films for content dissemination. However, a major reason for the defendant to film is to document events for review in case false criminal charges are levied on him by the police. Depending on the prosecutor, to spoon-feed the defendant his own evidence that has been manipulated benefits the prosecution and injures the defendant. This is classic judicial misconduct and fraud on this fucking court. Ah, gosh damn it. It's not January yet, so I'm not being held to my old fucking standards. It's devastating. Where am I going with this? Tell me. Number 40, the defendant noticed at the start of trial, C.O. Willis was not present to testify against the accused. The defendant has the right to face his accuser. C.O. Willis is the initial phone call complainant to Trooper Jones for this trespassing claim on Indian Ridge Access Road that day. Trooper Jones, while on scene, bypassed both Lieutenant Looney and the self-proclaimed acting warden of FCI McDowell, the lady in red, to interview C.O. Willis first. C.O. Willis and the acting warden, quote, the lady in red, were not at trial to testify against the defendant whom they accuse of trespassing on restricted FCI property. 41. The prosecution has yet to provide any documentation giving her the authority or jurisdiction to prosecute the federal trespass statute of, quote, 18 U.S. Code 1752, restricted buildings or grounds in the McDowell County Court, Magistrate Court. Indian Ridge Access Road is public access and not restricted. Therefore, defendant was not in a restricted area of FCI McDowell. 42. Up to this point, the defendant has proven judicial misconduct under the Code of Judicial Conduct for all three individual government entities involved in this case. Canon 1 of the Code of Judicial Conduct is a judge promote independence, integrity, and impartiality of the judiciary and should avoid impropriety and the appearance of impropriety. Blah, blah, blah. Rule 1, compliance with the law. A judge shall comply with the law, including the West Virginia Code of Judicial Conduct. Do you see where I'm going with it? Confidence in the judiciary. A judge shall act in all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Comment. The public confidence in the judiciary is eroded by improper conduct and conduct that creates the appearance of impropriety. This principle applies to both the professional and personal conduct of a judge. A judge should expect to be subject of public scrutiny that might be viewed as burdensome if applied to other citizens and must accept the restrictions imposed by the code. 3. Conduct that compromises or appears to compromise the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. Because it is not practicable to list all such conduct, the rule is necessarily cast in general terms. 5. Actual improprieties include violation of law, court rules of provisions of this code. The test for
appearance of impropriety is whether the conduct could create a reasonable mind a perception that the judge violates this code or engages in other conduct that reflects adversely on the judge's honesty, impartiality, temperament, and fitness to serve as judge. Canon 2. Here's where it gets juicy. A judge shall perform the duties of judicial office impartially, competently, and diligently. Rule 2, impartiality and fairness. A judge shall, upon and apply the law, and shall perform all duties of judicial office fairly and impartially. 4, it's not a violation of this rule for a judge to make reasonable accommodations to ensure pro se litigants the opportunity to have their matters fairly heard. Rule number 2.3, biased, prejudice, and harassment. A judge shall perform the duties of judicial office, including administrative duties, without bias or prejudice. B, a judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice, or engage in harassment, including but not limited to bias, prejudice, or harassment based on race, sex, gender, national origin, ethnicity, disability, age, sexual orientation, marital status, socioeconomical status, or political affiliation. Ooh, that's a good one. And shall not permit court staff, court officials, or others subject to judge's discretion and control to do so. Others. C, a judge shall require lawyers in proceedings before the court to refrain from manifesting bias and prejudice. Oh no, the judge can tell a lawyer? Or engage in harassment based upon attributes, including but not limited to race, sex, gender, blah. Look, political parties, witnesses, lawyers, and others. Uh-oh. Comment. A judge who manifests bias or prejudice in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Do we get where we're going now? Jack, you're pretty smart. Tell me where I'm going. John D. Nicola, you're getting pretty close. Examples of manifestations of bias, prejudice are not limited to epithets, slurs, demeaning nicknames, negative stereotypes, attempted humor based upon stereotypes, threatening, intimidating, or hostile acts, suggestions of connections between race, ethnicity, nationality, and crime, and irrelevant reference to personal characteristics. A judge must avoid conduct that may reasonably be perceived as prejudice or bias. 2.4, external influences on judicial conduct. A judge shall not be swayed by public clamor or fear of criticism. A judge shall not permit family, social, political, financial, or other interests or relationships to influence the judge's judicial conduct or judgment. C, a judge shall not convey or permit others to convey the impression that any person or organization is in a position to influence the judge. Nobody on the stand is going to do that. No. Comments. An independent judiciary requires that judges decide cases according to the law and facts, without regards to whether particular laws or litigants are popular or unpopular with the public, the media, government officials, or the judge's friends or family. Confidence in the judiciary is eroded if judicial decision-making is perceived to be subject to inappropriate outside influences, like talking to the fucking witness on the stand while I'm in another room. Here we go. Ensuring the right to be heard. 2.6. A judge shall accord to every person who has a legal interest in the proceeding, or that person's lawyer, the right to be heard according to the law. B, a judge may encourage parties to a proceeding and their lawyers to settle matters in dispute
but shall not act in a manner that coerces any party in the settlement. Ricky Bobby Jones, the plea maker, the plea deal maker. You know where I'm going here? Comments. The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedure protecting the rights to be heard are observed. 2. The judge plays an important role in overseeing the settlement of disputes. Ricky Bobby Sue Jones, plea deal maker, Judge Dredd. But she be careful that efforts to further settlements do not undermine any party's right to be heard according to the law of Ricky Bobby Sue Jones. Miss Puckett, why didn't you offer me that plea deal instead of him, the guy with the badge? The judge should keep in mind that the effects that the judge's participation in settlement discussions may have, not only on the judge's own view of the case, but also on the perception of the lawyers and the parties if the case remains with the judge after the settlement efforts are unsuccessful. Among the factors that a judge should consider when deciding upon an appropriate settlement practice for a case are, number 1, whether the parties have requested or voluntarily consented to a certain level of participation by the judge in the settlement. Hey, judge, you can come in. Or 2, whether the parties and their counsel are relatively sophisticated in legal matters. Am I? I don't know. Whether the case will be tried by the judge or a jury. I asked for a jury trial, but I didn't get it. Judge, I didn't get a jury trial. Why? 4, whether the parties participate with their counsel in a settlement discussion. Number 5, notice counsel. Nothing about no state troopers in this motherfucker. Number 5, whether any parties are unrepresented by counsel. Me, I'm my own advocate. Number 6, whether the matter is civil or criminal. And number 7, whether the case is pending before a specialized tribunal such as mass litigation, blah, blah, blah. Okay, we're almost done. Rule 2.8, decorum, demeanor, and communication with jurors. Hey, a judge, who is the jury in this case, shall require order, decorum in the proceedings before court. B, a judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, court staff, court officials, and others with whom the judge deals in an official capacity, shall require similar conduct of lawyers, staff, court officials, and other subjects to the judge's discretion. Ricky Bobby Sue Jones. Why are you threatening to arrest me in a courtroom, Ricky Bobby Sue Jones? Isn't that the judge's, the magistrate's job? Ricky Bobby Sue Jones. Comment. The duty to hear all proceedings with patience and courtesy is not inconsistent with the duty imposed in Rule 2.5 to dispose promptly of the business of the court. Judges can be efficient and businesslike while being patient and deliberate. Have we done that, Judge? Maybe too much patience. 2.9, ex parte, John D. Nicola. Who did I think you mentioned it? A judge shall not initiate, permit, or consider ex parte communication or consider other communication made to the judge outside the presence of the party or their lawyers. Judge, concerning a pending or impending matter, except as follows. 1, when circumstances require it, ex parte communication for scheduling, administrative, and emergency purposes, which does not address substantive matters, is permitted. Yes. A judge reasonably believes that no party will gain a procedural, substantive, and tactical advantage as a result of the ex parte yuck 'em up in the courtroom communication. I mean, ex parte communication. The judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives the party an opportunity to respond. Did I get that, Judge? While you were in there yucking up with the court? I didn't know what was going on there. Do you? I think I might subpoena you. Testify as a fact witness, Judge, Magistrate. Okay. The judge makes B, provisions promptly to notify all parties, which you didn't do, of this ex parte communication and gives the parties an opportunity to respond. A judge may consult with the court staff and court officials whose functions are to aid the judge in carrying out adjudicative responsibilities, and with other judges, provided the judges make reasonable effort to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. 4, the judge may, with the consent of the parties, confer separately with the parties and their lawyers in an effort to settle matters pending before the judge. A judge may initiate, permit, and consider any ex parte communication when expressly authorized by law to do so. B, if a judge inadvertently receives an unauthorized ex parte communication bearing upon the substance of matter, the judge shall make provisions promptly to notify the parties of the substance of the communication and provide the parties with an opportunity to respond. Judge, I want to know what you were yucking up about there out there with the witness, Lieutenant Looney. C, a judge shall not investigate facts in a matter independently. Judge, why are you communicating with that Lieutenant Looney on the stand, Judge? And shall consider only the evidence presented and any facts that may properly be judiciously noticed. A judge shall make reasonable effort, including providing appropriate supervision to ensure that this rule is not violated by the staff, court officials, Miss Puckett opening up that door. That's ex parte. By letting everybody in the courtroom hear what was going on inside that sequestered room. You understand? You opened up the door, Miss Puckett. Why did you have to open up the door so I could hear and see things going on in the courtroom? You thought you were going to be sly. You thought you were going to let everybody hear, including the witness, on the stand mere 20 feet away. And other subject to the judge's discretion and control. The judge told us to go into that room, Miss Puckett. So why did you ignore the judge's order, Miss Puckett, to sequester the fucking room? Go in private. So there was no ex parte communication. Only to find out there was ex parte communication, but it was on the other side of the door that you had cracked open. Stupid! You people are stupid! Comment. To the extent reasonably possible, all parties and their lawyers, not Ricky Bobby Trooper Super Judge Dredge Jones, shall be included in communication with the judge. Why are you talking to the judge, Judge Dredd, Trooper Ricky Bobby Sue Jones? Is that not an ex parte communication? He's an expert witness. He's the investigator, the professional witness. What is he doing answering your questions, Judge? When it should be Miss Puckett answering your questions, Your Honor. That would be proper, according to these rules. And Looney. Of course, Looney's ex parte. That's the basic meaning of ex parte. Me to you, or the judge to him. But ex parte is broader, letting information into the courtroom that's supposed to be sequestered. That's the judge's obligation to not allow that to happen. And if he does, he should tell you immediately that it was heard. So that we can be heard. I can be heard. You've defrauded me, Judge. You've taken my rights to be heard about what happened in the courtroom. Ex parte communication style. Whenever the presence of a party or notice to a party is required by this rule, it is the party's lawyer, or if the party is unrepresented, the party who is to be present or to whom notice is to be given. Number 3, the prescription against communication concerning a proceeding, including communication with lawyers, law teachers, and other persons who are not participants in the proceeding, except to the limited extent permitted by this rule. Yeah. Number 6, the prohibition against a judge investing the fact in a matter extent to information available in all mediums, including electronic. Importantly, this provision is not intended to refer to routine court records available for the bench, as long as the record are disclosed to and subject to review by the party. A judge may request the parties to submit proposed findings of fact and conclusions, sounds like what I'm doing now, so long as the parties are apprised of the request and are given an opportunity to respond to the proposed findings and conclusions, right? Rule 10, 210. Judicial statement on pending and impending cases. A judge shall not make any public statement that might reasonably be expected to affect the outcome or impair the fairness of matters pending or impending in any court, or make any non-public statement that might substantially interfere with a trial or hearing. Judge, when you talked to the defendant, Lieutenant Looney, you took away the you impaired the fairness of the matter pending. As soon as you yucked them up and started blabbering all over the courtroom, Judge, you made public statements in a public courtroom open to anybody. You did not take Looney off the bench. You did not postpone and tell Looney to get off of the bench, to go outside. Same with you. Why didn't you go outside and smoke a cigarette like you did in the first plea bargain deal at the beginning? You left the room and you went outside and you smoked a cigarette, and I said, no, I'm not going to plead out. So you come back in the room and we set a date for trial. That's when I gave discovery. You should have done the same thing here, Judge, Magistrate. But you kept everybody in place except for the parties. The parties were elsewhere in a room, sequestered. B, a judge shall not, in connection with cases, controversies, or issues that are likely to come before the court, make pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties of the judicial office. The judge shall require court staff, court officials, and others subjected to the judge's discretion or direction and control to refrain from making statements that the judge would be prohibited from making by paragraph A and B. So when Lieutenant Looney was talking, Judge, who was he talking to? Magistrate. And is that all right? D, notwithstanding the restriction in paragraph A, a judge may make public statements in the course of official duties, may explain the court procedure, and may comment on any proceeding in which the judge is a litigant in a personal capacity. Oh, no. Personal capacity? Like, can I subpoena you, Magistrate? E, subject to the requirements of paragraph A, a judge may respond directly or through a third party to allegations if the media or elsewhere concerning the judge's conduct in a matter. Or elsewhere concerning a judge's conduct? Oh, where could this be going? A trial for dismissal? Yes, I asked for dismissal in this. But that isn't what I'm doing, John D. Nicola, but another good try. Comments. This rule restricts the judicial speech are essential to the maintenance of the independence, integrity, and impartiality of the judiciary. This rule does not prohibit a judge from commenting on proceedings in which the judge is a litigant in a personal capacity or represents a client as permitted by the rules. Number 3, depending on the circumstances, the judge should consider whether it may be preferable for a third party rather than the judge to respond or issue statements in connection with alleged allegations concerning the judge's conduct in a matter. Do you see where I'm going? John D. Nicola, I'm giving you hints. Disqualification. Rule 211, disqualification. A judge shall disqualify himself or herself if any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. Number 1, the judge has a personal bias or prejudice concerning a party or a party's lawyer or personal knowledge of facts that are in dispute in the proceeding. Rule 215, respondent to judicial and lawyer misconduct. A judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, and fitness as a lawyer in other respects shall inform the appropriate authority. Judge, you gotta. At this point, the judge having knowledge indicating a substantial likelihood that a lawyer has committed a violation of the rules of professional conduct shall take appropriate action. Comment. Number 1, taking action to address known misconduct is a judge's obligation. Paragraph A and B impose an obligation on the judge to report to the appropriate disciplinary authorities the known misconduct of other judges or lawyers that raise a substantial question regarding the honesty, trustworthiness, or fitness of the judge or lawyer. Ignoring or denying known misconduct among one's judicial colleagues or members of the legal profession undermine a judge's responsibility to participate in efforts to ensure public respect for the judicial system. This rule limits the reporting obligation to those offenses that an independent judiciary must vigorously endeavor to prevent. Number 2, in the comment, a judge who has knowledge indicating a substantial likelihood of misconduct by another judge or lawyer is required to take the appropriate actions under paragraphs C and D. Appropriate actions may include, but not limited to, communicating directly with a judge who may have violated this code, communicating with the supervising judge, or reporting the suspected violation to the appropriate authorities or other agency or body. Similarly, actions to be taken in response to information indicating that a lawyer has committed a violation of the rules of professional conduct may include, but not limited to, communicating directly with the lawyer who may have committed the violation, or reporting the suspected violation to the appropriate authorities or other agencies or body. Rule 2.16, cooperation with disciplinary authorities, Your Honor. Magistrate, judge. A judge shall cooperate and be candid and honest with judicial and lawyer disciplinary agencies. A judge shall not retaliate directly or indirectly against a person known or suspected to have assisted or cooperated in the investigation of the judge or lawyer. Comment. Cooperation with the investigation and proceeding of judicial and lawyer discipline agencies is required in paragraph A, instills confidence in judges, commitment to the integrity of the judiciary system and the protection of the public. Administrative rules for magistrate court. This is where it kind of gets kind of weird. Not weird. Rule number 9, cameras in the courtroom. Upon request and with the concurrence of the supervising judge, the magistrate may permit the quiet and unobtrusive use of a camera in the courtroom in accordance with the rules governing camera coverage of the courtroom proceedings. Coverage. With the rules governing camera coverage of the courtroom. Can I say it again? As amended by order entered 1991. This comes straight from the West Virginia judiciary. And this is backing it up. West Virginia Trial Court Rule 8.06. The following equipment and persons shall be the maximum equipment and broadcast personnel permitted in the courtroom at any one time. One portable television camera or film camera with not more than one person operating the same. What does that mean? What does that mean? Rules number 9, cameras in a courtroom. It says camera coverage. What does that mean? The following equipment and persons shall be the maximum equipment and broadcast personnel permitted in the courtroom at any one time. I'm not a broadcast, I'm a litigant. I'm a defense counsel. Let's read on. A, one portable television camera or film camera with no more than one person operating at one time. What does that mean? One still photographer with one camera and not more than 2 lenses and necessary related equipment. What does that mean? Does that mean me? Me? Does that mean that I'm restricted from recording in this courtroom with no record? Hey, can you tell me? What does this mean? Let's read on. C, as used in these rules, television equipment in quotes includes both film and videotape cameras. Only television equipment which does not produce distracting sound or light shall be employed in the courtroom. No artificial lighting other than that normally present in the courtroom shall be employed in the courtroom except that, with the concurrence of the presiding officer, modifications and additions may be made to lighting in the courtroom, provided that such modifications or additions are installed and maintained without public expense. What does it mean? What does it mean? Tell me. Does it mean me? Can I not film in a courtroom? Am I the broadcast media? Do I have a big camera? What does it mean? Okay, let's find out some more. This is the last paragraph. Audio equipment of any type shall not be permitted in the courtroom at any time without prior permission of the presiding officer. If permission is given, not more than one audio system for audio broadcast shall be for audio radio broadcast shall be permitted in any proceeding if a technically suitable audio system exists in the court facility. Audio pickups for both radio and television shall be accomplished from such a system. If a technically suitable audio system does not exist in the court facility, microphones and related wiring shall be unobtrusive and shall be located in places designed in advance of the proceeding by the presiding officer. What does that mean? To me, it means that I have every right to film in that courtroom, especially if it's my trial. And the only reason why they wrote this rule is to ensure that the press doesn't go crazy. And it all started with the Lindbergh kidnapping. The media went fucking berserk at the Lindbergh trial. They were madhouse. The press was everywhere screaming, shouting, hollering, hooting, and shit. So they clamped down on the media in the courtrooms up until 1972-ish. West Virginia was one of the very first states most liberal when it come to filming in the courtroom, especially magistrate and circuit courts. But they wanted to ensure that the media didn't do a Lindbergh on them. So that's the way I interpret this. Do you interpret it the same way? Now, let's get to next year. What am I filing? I'm filing this. Filing a motion to disqualify Magistrate Richard Van Dyke, judicial misconduct. See attached sheets page 1 through 22 for the evidence of judicial misconduct by Magistrate Van Dyke. One thumb drive is also included on which is video and audio recorded evidence cited in the attached pages 1 of 22. So, I want the magistrate be disqualified. Get out of here, Judge. Magistrate. We just got done reading page 1 through 22. That was my motion. Do you get it? What do you think? Do you think I could get away with it? But wait for it. Wait for it. I'm filing another motion. This motion is to disqualify the prosecutor, Brittany Puckett, for judicial misconduct. Brittany, I'm giving you every fucking thing that I'm going to do in my trials and tribulations right here. Judge, I'm telling you what I'm going to be filing this week. Right here. And I'm going to stop this shit in its tracks. And I'm going to have you gone. Both you and Miss Puckett. Give me a thumbs up. Do you think I should do it? Do you think I should ask a higher court to review 1 of 22 pages with audio? What about video? Why would I throw that video part there and there at the end? I mean, I don't get it. It's called cutting the head off. The analogy of cutting the head off of a snake to stop something dead in its tracks that's venomous, poisonous, slithery, slimy. But man, I have a bombshell. Just a fucking bombshell. And I'll prove every fucking thing that I'm saying is correct. Every fucking. Oh, it goes so much more than just a report. It goes into the judicial misconduct. I got you dead to rights, man. I got all of you dead to rights. Now we're gonna have to delay the trial again, and hopefully the senior judge, circuit court judge, will see it my way and remove these 2 judicial branch officials. And the least I expect is a mistrial.